Welcome to the second part of the Indian Digital Personal Data Protection Act, or DPDP Act. The course has been broken into 3 parts. In this part, we will start with the rights and duties of data principals, roles, responsibilities of data fiduciaries, significant data fiduciaries, and consent managers. Let's discuss about rights of data principals. We'll discuss an important right that individuals have: the right to access information about personal data. So, what does this right entail? Essentially, it empowers individuals, known as data principals, to request information about the personal data that is being processed by a data fiduciary. This is all about transparency and giving you control over your personal information. When you exercise this right, you can expect to receive 1. A summary of your personal data. This includes a clear overview of the personal data being processed by the data fiduciary. For example, if you're using an online shopping site, they should provide you with a summary of what information they have about you, like your name, address, and purchase history. 2. Details on sharing. You'll also get information about any other data fiduciaries or data processors with whom your personal data has been shared. This means if your data was passed on to a payment processor or a marketing partner, you'll know who they are and what specific data was shared. Imagine wanting to know if your email address was sent to third-party advertisers. This right ensures you're informed. 3. Additional information. The Act allows for any other relevant details related to your personal data and its processing as prescribed by regulations. This could include how long your data will be retained or the purposes for which it is being used. So, what does this right mean? Essentially, it allows individuals, referred to as data principals, to request corrections, updates, or even the complete erasure of their personal data that they have previously consented to be processed. This right is all about ensuring that your personal information is accurate and reflects your current situation. Let's break it down. 1. Right to correction. If you notice that the personal data held by a data fiduciary is incorrect or incomplete, you have the right to request corrections. For example, if you've recently changed your address but the online service still has your old address, you can ask them to update it. This ensures that organizations have accurate information, which is crucial for effective communication and service delivery. 2. Right to completion. Sometimes, personal data may be incomplete. If you find that certain necessary details are missing, like your phone number on a profile, you can request that these gaps be filled in. 3. Right to erasure. You also have the right to request the complete deletion of your personal data. If you decide you no longer want a particular app or service using your information, you can ask them to erase all related data. This is especially important for individuals who want to take control of their digital footprint and ensure their data isn't retained longer than necessary. So, what is the right of grievance redressal? This right ensures that individuals, known as data principals, can raise complaints regarding how their personal data is being handled by data fiduciaries. It's all about accountability and providing a clear channel for addressing any issues that arise. When you have concerns about your personal data, whether it's about unauthorized access, mishandling, or any other related issue, you have the right to seek redress. The right of grievance. Redressal empowers individuals to hold organizations accountable for their data handling practices. It provides a structured way for you to voice concerns and seek resolutions, ensuring that your rights under the DPDP Act are respected. So, what is the right to nominate? This right empowers you, as a data principal, to nominate another individual who can exercise your data rights on your behalf. This is particularly significant in situations where you may be unable to act for yourself due to circumstances like death or incapacity. Let's break it down further. 1. Who can be nominated? You can choose anyone you trust to act on your behalf regarding your personal data rights. This could be a family member, a close friend, or a legal representative. The key here is that this nomination ensures your interests are protected even when you cannot advocate for yourself. 2. Scope of the right. The nominated individual can exercise all the rights that you hold as a data principal. This includes rights like accessing your personal data, requesting corrections, or even seeking erasure of your information. Essentially, it allows someone else to step into your shoes and manage your data rights effectively. 3. Process of nomination. While the specific process for making this nomination will be outlined in the rules of the Act, it's designed to be straightforward. You'll need to follow prescribed guidelines to ensure that your nomination is valid and recognized by data fiduciaries. 4. Protection. During incapacity. The term incapacity refers to situations where you might be unable to exercise your rights due to mental or physical conditions. In this segment, we'll discuss the important duties of data principals. That's you, the individual whose personal data is being processed. As a data principal, you have specific responsibilities to ensure that your rights and the rights of others are respected. Let's break down these duties. Compliance with laws. First and foremost, you need to comply with all applicable laws while exercising your rights under this Act. This means being aware of and following the legal requirements when you interact with organizations regarding your personal data. No impersonation. It's essential not to impersonate another person when providing your personal data. For example, if you're signing up for a service, make sure you're using your own information and not someone else's. This helps maintain the integrity of data processing. Transparency in information. You should never suppress any material information when providing your personal data. If you're asked for proof of identity or address, like a government-issued ID, be honest and provide accurate details. In this section, we'll explore the obligations of data fiduciaries, the organizations that handle your personal data. So, who is a data fiduciary? They are the entities that decide how and why your personal data is processed, holding significant responsibility for protecting your information. One of their primary obligations is to have valid grounds for processing personal data. Here are some key points they must consider. 1. Obtaining consent. Data fiduciaries must get your explicit consent before processing your data. Think of it as giving permission before someone takes a photo of you. Your consent must be clear and informed. 2. Purpose limitation. They can only use your data for specific purposes you've agreed to. For example, if you sign up for a newsletter, your email should only be used for that purpose. 3. Data minimization. They should collect only the data necessary for their stated purpose. If you're shopping online, they don't need to know your favorite color, just your shipping address and payment details. 4. Accuracy and completeness. Data fiduciaries must ensure that the personal data they collect is accurate and complete. If you change your address, it's their job to update that information promptly. 5. Security measures. Protecting your data is crucial. They must implement appropriate security safeguards to prevent breaches, such as encryption and secure servers. 6. Breach notification. If there's a data breach, they must inform you and the Data Protection Board promptly, so you can take action. 7. Data retention and erasure. Once the purpose for collecting your data is fulfilled, they must delete it unless there's a legal reason to keep it longer. So, what's notice all about? Well, before any organization collects your personal data, they need to provide you with a clear notice. This isn't just a formality. It's your right to know what's happening with your information. The notice should explain exactly what data they're collecting and why. For instance, if you're signing up for a new app, you should see details about what personal information they need and how they plan to use it. Now, this notice can come in different formats. It might be a separate document, an electronic message, or even part of the sign-up form itself. The key is that it has to be easy to understand. No legal jargon. It should be written in plain language so you know exactly what you're consenting to. And remember, it should be available in English or any of the 22 regional languages used in India. Another important point is that the notice must inform you that you can withdraw your consent anytime. If you change your mind about sharing your data, you should know how to do that easily. The notice should include a direct link to a section for easily managing and withdrawing consent, with alternative methods such as email or a toll-free number for accessibility. Withdrawal should be as simple as granting consent, ideally with a one-click option. Data fiduciaries also have to keep records showing they provided this notice and got your consent properly. If they mess up and don't follow these rules, your consent is considered invalid. Lastly, even in cases of deemed consent, where consent is assumed, they still need to provide notice so you're aware of how your data will be used. Under the DPDP Act, organizations can process your personal data without obtaining prior consent in specific situations known as legitimate uses. This means there are scenarios where your data can be used without needing to ask you every time. Let's explore some of these legitimate uses. First up, employment purposes. If you're applying for a job, your potential employer can process your personal data to evaluate your application. This includes checking your qualifications and background. It's all about ensuring they have the right information to make informed hiring decisions. Next, there's the need for organizations to protect themselves from potential loss or liability. For instance, a company might need to process employee data to prevent corporate espionage or safeguard trade secrets. This helps maintain a secure workplace for everyone. Another important legitimate use is in emergencies. If there's a medical crisis or a public disaster, organizations can process personal data to provide assistance or ensure safety. Imagine a situation where quick access to medical records could save lives. This provision allows for that swift action. Lastly, compliance with legal obligations is also a legitimate use. If authorities require information for investigations or legal proceedings, organizations must comply without needing explicit consent from individuals. Under the DPDP Act, data principals, those whose personal data is processed, are granted specific rights. These include the right to access their data, request corrections, and even seek erasure of their information. It's essential for organizations to facilitate these rights effectively. To enable data principals to exercise their rights, the DPDP Act mandates that data fiduciaries and, where applicable, consent managers must publish clear information on their websites or apps. This includes details on how individuals can make requests to exercise their rights. Additionally, organizations must specify any particulars required to identify a data principal under their terms of service. This could include information like usernames or other identifiers that help verify the identity of the individual making the request. For instance, if a user wants to delete their account, they may need to provide their registered email address as part of the process. The DPDP Act emphasizes the importance of reasonable security safeguards to prevent unauthorized access and data breaches. First, let's discuss appropriate data security measures. This includes securing personal data through methods such as encryption, obfuscation, or masking. For instance, encrypting sensitive information like financial records ensures that even if unauthorized access occurs, the data remains unreadable. Another critical aspect is controlling access to computer resources. Organizations must implement strict access controls to ensure that only authorized personnel can access personal data. For example, a healthcare provider may restrict access to patient records only to medical staff who need that information. Visibility on accessing personal data is vital for detecting unauthorized access. Organizations should maintain logs and monitoring systems that allow them to track who accesses personal data and when. This enables timely detection of any unauthorized attempts. In case of a breach or compromise of personal data, Organizations must have measures in place for continued processing. This includes having backup systems to restore lost data and ensuring that operations can continue without significant disruption. To effectively detect unauthorized access, organizations are required to retain logs and personal data for 1 year unless otherwise mandated by law. This retention period allows thorough investigations into incidents. It's also essential for organizations to include provisions in contracts with data processors regarding security safeguards. This ensures all parties involved in processing personal data are aligned in their commitment to maintaining robust security measures. Finally, organizations must implement appropriate technical and organizational measures to ensure effective observance of these security safeguards. A personal data breach occurs when there is unauthorized access to or loss of personal data. The DPDP Act mandates that organizations take immediate action when they become aware of such breaches. Upon becoming aware of a breach, the data fiduciary must promptly inform each affected data principal. This communication should be concise, clear, and plain. It should be delivered through the user account or any registered communication method. For example, if a user's data was compromised, they should receive a notification via email or through the app they use. The notification must include several key elements. 1. Description of the breach. This includes details about the nature, extent, timing, and location of the breach. 2. Consequences. The organization must explain the potential consequences relevant to the affected individuals. 3. Mitigation measures. It's important to inform data principals about the measures implemented or being implemented to mitigate risks associated with the breach. 4. Safety measures for individuals. Organizations should advise individuals on steps they can take to protect their interests. 5. Contact information. Finally, provide business contact information for someone who can respond to queries from data principals. In addition to informing affected individuals, the data fiduciary must also notify the regulatory authority, the board, without delay. This notification should include a description of the breach and its likely impact. Furthermore, within 72 hours of becoming aware of the breach, organizations must provide updated and detailed information. The DPDP Act outlines that data fiduciaries must erase personal data when it is no longer necessary for the purposes for which it was collected. This means that if a data principal does not approach the data fiduciary for a specified purpose or exercise their rights within a defined time period, the organization is required to erase that data. This provision emphasizes the importance of data minimization and accountability in data processing. Importantly, at least 48 hours before the completion of this time period for erasure, the data fiduciary must inform the affected data principal. This notification should be clear and straightforward, letting individuals know that their personal data will be erased unless they take action, like logging into their user account or contacting the organization for further engagement. For example, if a user hasn't interacted with their account for a while, they should receive a reminder about the impending erasure of their data. In this context, a user account refers to any online account registered by the data principal with the data fiduciary. This includes profiles, email addresses, mobile numbers, and other identifiers used to access services. Being classified as an Significant Data Fiduciary, or SDF, means that an organization has a heavier compliance burden. Let's break down these key obligations that come with this designation. First up is the requirement for Data Protection Impact Assessments, DPIAs. SDFs must regularly conduct these assessments to identify and mitigate risks associated with their data processing activities. It's all about ensuring that they understand how their operations impact individual privacy. Next, there's the appointment of a Data Protection Officer, DPO. This individual is responsible for overseeing data protection compliance and serving as a point of contact for both the organization and data principals. The DPO plays a crucial role in ensuring that privacy practices are followed. SDFs are also required to perform periodic data audits. These audits help verify that data handling practices align with legal requirements and internal policies. It's an essential step in maintaining accountability and transparency. Another obligation is the maintenance of records. SDFs must keep detailed records of their data processing activities, including what data is collected, how it's used, and who it's shared with. Lastly, SDFs have additional reporting obligations. They must report any significant incidents or breaches to the Data Protection Board promptly, ensuring that there's no delay in addressing potential risks to personal data. Coming to data protection impact assessments, commonly known as DPIAs. So, what exactly is a DPIA? Think of it as a proactive measure that organizations take to assess how their data processing activities might impact your privacy. Under the DPDP Act, particularly for significant data fiduciaries, conducting a DPIA isn't just good practice. It's a requirement for high-risk processing activities. When an organization conducts a DPIA, they systematically evaluate potential risks to data principals like you. This includes looking at how personal data is collected, stored, and shared. For example, if a company plans to launch a new app that collects sensitive health information, they must assess what could go wrong, like data breaches or unauthorized access, and take steps to mitigate those risks before moving forward. The process involves documenting findings and implementing strategies to address any identified risks. This means that if they find potential issues during the assessment, they need to put measures in place to protect your data before they start processing it. Significant data fiduciary shall, once in every period of 12 months from the date on which it is notified as such, or is included in the class of data fiduciaries notified as such, undertake a data protection impact assessment. Under the DPDP Act, every significant data fiduciary is required to appoint a data protection officer, or DPO. This person is crucial for ensuring that the organization complies with data protection regulations. But what exactly does a DPO do? First and foremost, the DPO acts as the main point of contact for data principals, those individuals whose personal data is being processed. If you have questions or concerns about how your data is being handled, the DPO is there to help. They facilitate communication between you and the organization, ensuring your rights are respected. Importantly, the DPO must be based in India. This requirement ensures that they are accessible and can respond promptly to inquiries from both data principals and the Data Protection Board. The DPO also plays a key role in overseeing compliance efforts within the organization. They monitor adherence to data protection policies, provide guidance on best practices, and help conduct data protection impact assessments, DPIAs. So, what exactly are periodic data audits? These are essential evaluations that organizations, especially significant data fiduciaries, must conduct to ensure they're complying with data protection regulations. The goal is to assess how well they handle personal data and identify any potential risks or areas for improvement. One key requirement is that organizations must engage independent auditors to carry out these assessments. This independence is crucial because it provides an unbiased evaluation of the organization's practices. During these audits, the auditors will review various aspects of data processing, including how personal data is collected, stored, and shared. They'll evaluate whether the organization has implemented adequate security measures and whether they're adhering to the principles outlined in the DPDP Act. Under the DPDP Act, organizations, especially significant data fiduciaries, are required to maintain detailed records of their data processing activities. But why is this so important? First and foremost, keeping accurate records helps ensure transparency. It allows organizations to track what personal data they collect, how they use it, and who they share it with. This level of documentation is essential for building trust with data principals. those individuals whose data is being processed. Particularly for high-risk processing activities, maintaining thorough records is crucial. For instance, if an organization processes sensitive personal data, like health information or financial details, they must document every aspect of that processing. This includes the purpose of data collection, the legal basis for processing, and any third parties involved. Under the DPDP Act, organizations, especially those classified as significant data fiduciaries, have specific responsibilities when it comes to reporting incidents. One of the most critical obligations is to report any significant data breaches promptly to the Data Protection Board. What does this mean in practice? If an organization becomes aware of a data breach, say, unauthorized access to personal data, they must notify the Data Protection Board within a specified time frame. This ensures that regulatory authorities can take necessary actions to mitigate any potential harm and protect the rights of affected individuals. Let's understand the role of Consent Manager under the Indian Digital Personal Data Protection Act, 2023. A consent manager acts as an intermediary between individuals, known as data principals, and organizations that process personal data, referred to as data fiduciaries. Their primary function is to enable individuals to provide, manage, and withdraw their consent for the processing of their personal data. For example, when you sign up for a new app that collects your personal information, a consent manager ensures that you can easily give or revoke your consent regarding how that information is used. To operate as a consent manager, entities must register with the Data Protection Board of India, DPDP. This registration process requires them to meet specific criteria, including having a minimum net worth of Rs 2 crore and demonstrating sufficient operational capacity. This ensures that only capable organizations can manage sensitive consent processes effectively. By setting these standards, the Act aims to protect individuals' rights while ensuring that consent managers are equipped to handle their responsibilities. Consent managers have several critical responsibilities. They facilitate the collection of consent from individuals and maintain detailed records of consents given, denied, or withdrawn. These records must be kept for at least 7 years. For instance, if you decide to withdraw your consent from a service provider, the consent manager must accurately reflect this change in their records. Additionally, consent managers are prohibited from subcontracting these obligations to other entities, ensuring accountability and direct oversight in managing consent. To make managing consent easy for individuals, consent managers must develop user-friendly platforms, either websites or mobile applications. Imagine logging into an app where you can see all the companies you've given permission to use your data and easily toggle your preferences. This transparency is crucial in building trust with users and empowering them to take control over their personal information. Consent managers are required to provide data principals access to their consent records in a machine-readable format. This means that if you want to see how your personal data is being used or shared, you can easily access this information through the consent manager's platform. This level of transparency not only helps individuals understand how their data is being managed, but also reinforces accountability among organizations that process personal data. Compliance with standards set by the Data Protection Board is non-negotiable for consent managers. They are subject to audits and compliance checks to ensure they are adhering to all provisions of the DPDP Act. For example, if a consent manager fails an audit due to inadequate record-keeping practices, they may face penalties or even lose their registration. This ensures that they remain accountable for their actions in managing individual consents. Finally, consent managers must establish effective grievance redressal mechanisms. If you have concerns about how your consent is being managed, or if you believe your rights have been violated, there should be clear channels through which you can raise these issues. Having a robust grievance mechanism not only enhances user trust, but also ensures that any issues can be addressed promptly and effectively.